Chapter 9. Remedies, Law and Equity. Section 451. The remedies against piracy are usually by an action on the case for an injury done to a trader in respect to his trademark, being a personal injury to be compensated by damages, or else by injunction. The law remedy is sometimes sought under the common law, and sometimes under statutes. Many of the states of the Union have legislated more or less upon the subject, and some of them have passed stringent penal laws in regard thereto. The first federal legislation in the matter is to be found in the trademark sections of the Patent and Copyright Enactment of July 8, 1870, and the remedies therein prescribed are purely of a civil nature, being, indeed, a reaffirmance of the provisions of the pre-existing rules of common law and equity, and novel only in allowing an action for injuries resulting from false or fraudulent representations in the registry of a trademark. Section 452. Sometimes a remedy may be found by criminal indictment, either at common law or by the statutes of states. There are two heads of crime under which it might be expected that the fraudulent imitation of a trademark would be indictable, as a forgery, or as the obtaining of money under false pretenses. The former of these methods was adopted in the case of Reg. v. J. Smith, in England. The imitation in this case consisted of a printed label, which was an exact imitation of the labels attached by the prosecutor, George Boyke, to packets of his powder, called Boyke's baking powder, with this exception, that the signature, George Boyke, was omitted in the counterfeit. It was contended, on the part of the prosecution, that the term forgery might be defined as the alteration or making of a false document with intent to defraud, and cases were cited in which the fraudulent imitation of a printed document, such as a diploma of the College of Surgeons, the good conduct certificate of the master of a ship, and of a clergyman, as to the character of a schoolmaster, had been held to be forgeries. It was, however, unanimously held by the bench that the conviction was not sustainable, that the issuing of the wrapper or label, without the powder which it enclosed, would be no offence, and that, in the printing of the wrappers, there was no forgery committed by the printer. Bramwell, B., there said, forgery supposes the possibility of a genuine document, and that the false document is not so good as the genuine document, and that the one is not so efficacious for all purposes as the other, that, in the case before him, one of the documents is as good as the other, the one asserts what the other does, the one is as true as the other, but one gets improperly used. Mr. Lloyd, in his work on trademarks, says that he has not been able to find any case in the reports, in which an indictment for obtaining money under false pretenses has been sustained in the case of a fraudulent use of a trademark, although he had been referred to the cases of Reg. v. Gray and Gosling, in which the prisoners were sentenced to 12 months hard labor for the fraudulent use of the Messrs. Allsop's labels, and to another case of Reg. v. S. Jones, where a sentence of 3 years penal servitude was inflicted. He says that it is clear, however, that the principle is applicable, and, in the case first cited, Wis. J. says, in cases like the present the remedy is well known. The prosecutor may, if he pleases, file a bill in equity to restrain the defendant from using the wrapper, or he may bring an action at law for damages, or he may indict him for obtaining money for false pretenses. This opinion of Mr. Justice Wis was assented to, with more or less positiveness, by the other judges, and it seems strange, says Mr. Lloyd, that this form of indictment should not have come into use by manufacturers for the purpose of protecting their trademarks. It may, however, be accounted for on the ground that an action at law for damages, if successful, gives a more ample compensation for the violation of their rights. $453. Forgery at common law is defined to be the fraudulent making or alteration of a writing to the prejudice of another man's right, or as a false making, a making malo animo, of any written instrument for the purpose of fraud or deceit. In the case of Reg. v. J. Smith, above cited, Pollock, C.B., in giving judgment, said, speaking of the labels, they are merely wrappers, and, in their present shape, I doubt whether they are anything like a document or instrument which is the subject of forgery at common law. To say that they belong to that class of instruments, seems to me to be confounding things together as alike which are essentially different. It might as well be said, that if one tradesman used brown paper for his wrappers, and another tradesman had his brown paper wrappers made in the same way, he could be accused of forging the brown paper. So in Reg. v. Kloss, it was decided that the painting an artist's name in the corner of a picture, in order to pass it off as an original picture by that artist, is not a forgery. Coburn, C. J., in giving judgment, said, "We are all of opinion that there was no forgery. A forgery must be of some document or writing, and this was merely in the nature of a mark put upon the painting with a view of identifying it, and was no more than if the painter put any other arbitrary mark as a recognition of the picture being his." In the course of the argument of this case it was stated by the counsel that no case had gone the length of holding that to stamp the name of Manton on a gun would be forgery, upon which Crumpton, J., said, "That would be forgery of a trademark, and not of a name," and Coburn, C. J., said, "Stamping a name on a gun would not be a writing, it would be the imitation of a mark, not of a signature." Whether the common law embraced such cases or not, the subject, in England, is made clear, and the following offences are made misdemeanors by Section 2 of the Merchandise Marks Act of 1862. The forging or counterfeiting any trademark with intent to defraud. The applying a genuine, or a forged trademark, with intent to defraud, to anything not being the manufacture, and c. of any person denoted or intended to be denoted by such trademark, or not being the manufacture, and c. of the person whose trademark shall be forged. The applying any genuine or forged trademark, with intent to defraud, to anything not being the particular or peculiar description of manufacture, and c. denoted or intended to be denoted by such trademark. For instance, if a man has two trademarks, one for a particular description of goods of a superior quality, and another for a different description of goods of an inferior quality, the applying the trademark for the goods of superior quality to the goods of inferior quality, will be a misdemeanor, if done with intent to defraud, such intent being an essential ingredient in all such offenses. $454. Some of the states of this Union have passed statutes, declaring it to be a misdemeanor punishable by fine and imprisonment to forge or counterfeit, or cause to be forged or counterfeited, any representation, likeness, similitude, copy, or imitation of the private stamp, wrapper, or label affixed by any mechanic or manufacturer to his goods, wares, or merchandise, or in the sale thereof, with intent to deceive or defraud the purchaser or manufacturer of any goods, wares, or merchandise whatever. For our present purpose, it is hardly worthwhile to discuss these comprehensive enactments, which are not confined to technical trademarks, but embrace wrappers, stamps, and labels. It may, however, be well worthwhile to have recourse to local statutes when other means are inapplicable, as when, although the technical symbol is not imitated, mischief is done by the ingenious simulation of a label or a wrapper, in color, size, shape, and c. In such cases, of course, a federal court is not the proper forum, for such court possesses no power except such as both the Constitution and the Acts of Congress concur in conferring upon them. Section 455. The criminal law of some of the countries of Europe, especially France, is severe upon fraudulent imitators of trademarks. In the Tribunal of Reims, in 1863, Pliquot v. Raudet als, these facts appeared. In 1863, the London journals contained an advertisement of wines of the house of La Veuve Clicquot, of Reims, at advantageous prices, at the Victoria Dock. Suspicions were aroused. The boxes and the casks were found to bear counterfeit marks. The Court of Queen's Bench ordered the seizure of the wines. It transpired that an association, composed of Kaysen, a wine merchant, of Roud, his principal agent, and 3 Englishmen, were operating together, and selling wines under the counterfeited marks of Moet, d'Épinay, and Veuve Clicquot. All were deemed guilty in France, although the acts were consummated in England, and severely punished. So, also, in the Court of Paris, in 1867, Heidsieck v. Souris, Driesel, et als, Souris, a commission merchant, and Driesel, of Reims, in September 1866, formed a conspiracy with Theodore and George Bayard, merchants at New York, to imitate and usurp the trademark of Charles Hyde's, manufacturer of champagne wine and Reims, and to export the wine in large quantities to America. In pursuance of their plan, Souris caused to be engraved a mark like that of Charles Hyde's, and to be reproduced on the cork of each bottle, with the sole substitution of the name of Herman for that of Charles, in the same characters, and the accessory ornament representing a comet. Souris then proposed to export wine in baskets, whose covers bore the 4 red bars, and all the external appearances of those of the house of Charles Hyde's. Upon their arrival in America, labels were to be affixed, to complete the deception. It was shown that one Herman Hyde's, residing at Street, Louis, Mo, and not in the champagne wine business, had loaned his name to guarantee success. The court said that the nefarious conspiracy had been organized on a vast scale. 10,000 francs damages, costs, and c. were allowed. Section 456. In the Court of Paris, 1868, Martel and Company v. Baydroff Patel. The plaintiffs in this case were of Cognac, the products of which place are known in all the markets of Europe and America, and having been victims of numerous counterfeits, had seized in Baydroff's lithographic establishment in Paris 12,000 labels bearing their name, and entirely similar to those employed by them in their trade. Baydroff set up that he had made the false labels at the order of Pat. Held that the counterfeiting was complete by making, it not being necessary that use should be shown. The lithographer who reproduces the mark or label by order of a third person, without assurance that he is either the proprietor, or the agent of the proprietor of the mark, cannot set up his good faith. Damages against both. The court further ordered that the labels and stone from which they were printed should be destroyed, and that the judgment should be published in public journals to be selected by the plaintiffs. Section 457. It has been seen that the form of action adopted in vindication of the right to use a trademark, is that of an action on the case for deceit, that is, so far as the common law forms have escaped the renovating inroads of the new school of pleaders, and that action still survives under some other name, or no name, under the simplified forms of pleadings of the codes of procedure. Under the United States statutes, the action remains purely the old action on the case. $458. In this action, fraud is of the essence of the injury. There are, therefore, 2 main points to be proved: the fraudulent nature of the wrong committed by the defendant, and the nature of the injury suffered by the plaintiff. The nature of the wrong to be proved is well defined by Wilde, C.J., in Rogers v. Now Ill, where he says, "Has more ever been held necessary to be proved, in actions of this description, than that the plaintiff, being a manufacturer, has been accustomed to use a certain mark to denote that the goods so marked were of his manufacture, that such mark was well known and understood in the particular trade, and that the defendants had adopted the mark, and sold goods bearing it, as and for the plaintiff's goods, with intent to deceive." On these grounds, the action was held not to be maintainable in Singleton v. Bolton, for no sale was proved to have been made by the defendant of a medicament of his own under the mark of the plaintiff, but both the plaintiff and the defendant used the name of the original inventor, Dr. Johnson, and no evidence was given of the defendant having sold his ointment as if it had been prepared by the plaintiff. So, also, in Crawshay v. Thompson, it was held that the mark used by the defendants was not used with the intention of supplanting the plaintiffs, but that it was applied to certain goods in the ordinary course of business, and in execution of orders. This decision is grounded on the evidence in the case, and turns on the question of what constituted such a fraudulent use. There was no proof of an intention on the part of the defendants to sell their manufacture as and for that of the plaintiffs, but it was contended that their motive in using the mark was immaterial, if the resemblance in fact existed, and they were aware of it. In Blanchard v. Hill, Lord Hardwicke said, "It is not the single act of making use of the mark that was sufficient to maintain the action, but the doing it with a fraudulent design to put off bad cloths by this means, and to draw away customers from the other clothier." Maclean, J., said, in Coffin v. Brunton, that from the cases theretofore decided it would seem that an intentional fraud is not necessary to entitle the plaintiff to protection, for the injury will be neither greater nor less by the knowledge of the party. If he has adopted the same mark which will cause his article to be taken for another in the market, which is known and approved of, it is an injury which the law will redress. In commercial dealings, the utmost good faith should be observed, and no one is permitted to go into the market with a deception of this character, so as to profit by the good faith or established reputation of another. In Dale v. Smithson, Hilton, J., held that the right of the plaintiffs to maintain the action did not in any degree depend upon the inquiry as to whether the defendants intended to appropriate to their use a trademark or label, known by them to have been devised and employed by the plaintiffs in their business, but that it was enough if it was made to appear that the defendants did the act complained of, and so, although they may have used the mark in ignorance of its being the exclusive property of anyone. It must be observed that this case, although nominally an action under the Code of Procedure of the State of New York, is not the technical action on the case, but was really a suit in equity to restrain an infringement, and equity will restrain independent of motive. This principle has been so uniformly maintained by the courts, that it is almost supererogatory to cite further illustrations, but, to place the question still more clearly before the reader, we will look at other cases. In Blowfield v. Payne, the declaration stated that the plaintiff, being the inventor and manufacturer of metallic hones, used certain envelopes for the same, denoting them to be his, and that the defendant wrongfully made other hones, wrapped them in envelopes resembling the plaintiff's, and sold them as his own, whereby the plaintiff was prevented from selling many of his hones, and they were depreciated in value and reputation, those of the defendant being inferior. The court held that the plaintiff was entitled to some damages for the invasion of his right by the fraud of the defendant, though he did not prove that the defendant's hones were inferior, or that he had sustained any specific damage. Where a right is invaded by a fraudulent act, though no specific injury be proved, some damages, at law, must be given, as when a publisher of magazine or newspaper assumes the name of one previously published, or represents the new publication as a continuation of the former, when it is not so. In Marsh v. Billings, which was an action on the case, sounding in tort, and governed by the same principle which has been repeatedly recognized and acted on by courts, in reference to the fraudulent use of trademarks, it was held that the use of the words Revere House on coaches was a fraud on the plaintiffs, and a violation of their rights, for which an action would lie, without proof of actual or specific damages. The same rule was observed in Blowfield v. Payne, where it was held that by the defendant's act the plaintiff was entitled to some damages, inasmuch as his right had been fraudulently invaded. So, also, in Rogers v. Now ill, section 459, to entitle him to recover, it is necessary for the plaintiff to show that an actual damage has been suffered. But sometimes the law will presume damages, as where the defendant made and sold medicines, calling them Thomsonian medicines, as and for the medicines made and prepared by the plaintiff, so that persons purchasing the same supposed and believed that they were purchasing the medicines made and prepared by the plaintiff, for that was a fraud upon the plaintiff for which the law will presume some damage. Such a case, therefore, being proved, the plaintiff will be entitled to recover nominal damages, at least, and something more, if he can make it appear to the satisfaction of a jury that he has sustained more than nominal damage. Section 460. The nature of the wrong suffered by the trader whose mark is fraudulently used is twofold. It consists in the injury to his reputation where an article of inferior value is palmed off upon the purchaser, or else in the injury done to his trade by general diversion of custom. In Coffin v. Brunton, the court said, that if the defendant made representations that his liniment contained the same ingredients as that of the complainant, while in fact it was not only different from the Chinese liniment, but greatly inferior to it, the effect must be to destroy in the market the value of the complainant's liniment, and that would be ground for the equitable interposition of a court of equity. That is an injury for which a court of law cannot give adequate compensation. However valuable the complainant's invention may be, yet if it be discredited by a worthless article, it would be impossible, in any reasonable time, to restore the public confidence in the genuine article. In this consists the injury, and the fraud arises from the false representations that the composition is the same. Section 461. Nor need the representations be immediate in order to give a ground of action, as is shown by the case of Sykes v. Sykes. The defense proved that the sale of the spurious article was made to retail dealers, who were aware of the fraud, but nevertheless it was held that the sale to them for the purpose of a resale to the public, who would be deceived by the printed stamp, was substantially the same thing as a direct fraud by the original vendor. $462. Remedy inequity. As a general proposition, it is only when the legal title is clear that a court of equity will interfere by injunction to restrain the use, or the colorable infringement of a trademark. In cases of doubt, the court should not grant or retain an injunction until the cause shall have been heard upon the pleadings and proofs, or until the complainant shall have established his right by an action at law. Such was the decision of the New York Court of Appeals, in 1848. So the Lord Chancellor, in Spottiswoode v. Clark, who said that, unless the case be very clear, it is the duty of the court to see that the legal right is ascertained before it exercises its equitable jurisdiction. And he said that for this there are good reasons. The title to relief depends on a legal right, and the court only exercises its jurisdiction on the ground that that legal right is established. The objection to granting an injunction in the first instance is, that it promotes after litigation. The order either grants an injunction and compels the complainant to bring his action, or suspends the injunction, with liberty to the complainant to bring an action. If you compel him to go to a court of law, you promote litigation, and this course is forced upon parties at a time when their feelings are deeply engaged in prosecuting their imaginary rights. There is also, said he, another objection, which is, that the court expresses a strong opinion, and it ought to be a strong opinion, and then sends the right to be tried. It is better that the court should abstain from expressing such an opinion. But, after all, the chief objection is, that the court runs the risk of doing the greatest possible injustice, in case its opinion upon the legal right should turn out to be erroneous. If the plaintiff prove his title by a successful action at law, he is indemnified by the defendant in the account which the court has directed the latter to keep. On the other hand, if the plaintiff fail in his proof at law, there are no means in his power for compensating the defendant for the loss he will have sustained by the suspension of his trade during the operation of the injunction. This is a sufficient reason for withholding that remedy, unless there be a very clear preponderance of proof in favor of the complainant in the first instance, or some conduct be shown on the part of the defendant which renders it unadvisable to permit him to continue his trade upon the footing of an account to be taken. Mr. Justice McLean, in Coffin v. Brunton, said that the right of the party who claims protection must be clear, for, if it be controverted, Chancery will leave the party to his remedy at law, or, at least, to such a proceeding as shall present the whole merits of the controversy, and enable the court to decide it. Mr. Justice J., in the case of the Ameskig Manufacturing Company v. Speer, said that the rule is fully settled, and is recognized in nearly all the cases, that, in suits for infringements of trademarks, an injunction is never to be granted in the first instance, if the exclusive title of the plaintiff is denied, unless the grounds upon which it is denied are mainly frivolous. When the title is disputed, the course is to let the motion for an injunction stand over until the plaintiff has established his legal right in an action at law, and Mr. Justice J. cited with approval the ruling of Lord Cottenham, in Motley v. Downman, who used the strong expression that he cannot conceive a case in which the court will interfere at once by an injunction so as to prevent the defendant from disputing the plaintiff's legal title. Daly, J., in the Merrimack Manufacturing Company v. Garner, said that courts of equity have not interfered in cases of this kind, except in aid of a legal right, and if the fact of the plaintiff's property in the trademark, or if the defendant's interference with it has appeared at all doubtful, the plaintiff has been left to establish his case first by an action at law. Where the title of the plaintiff to appropriate a certain mark or name to himself was not made out, or considerable doubt existed respecting it, the court discharged an injunction order, upon the defendants entering into an undertaking in a penalty to keep an account of their sales, and render the same when required by a competent court. Section 463. The same principle has been applied by courts in the exercise of their jurisdiction in patent and copyright cases, and on the same grounds. In Stevens v. Keating, the learned judge said that if the injunction, having been once granted, turns out to be unfounded, you are doing an irreparable injury to the parties restrained, whereas, by withholding it, you may be permitting some injustice, but certainly not an injustice at all equal to that which you are doing by improperly granting it. In this case, the court went so far as to fix the time within which the plaintiff was to bring his action, and on his failing to proceed to the trial of that action, upon grounds which by the court were considered to be insufficient to justify his delay, and upon a subsequent motion on the part of the defendant, the injunction which had been granted on the merits of the case was dissolved, and the defendant was directed to keep an account of his profits. Section 464. The rendition of a verdict in a case in favor of plaintiff is not conclusive upon the right of such party to an injunction, where it is manifest that error has been done, but the considerations which would justify a judge in renewing the discussion of a patentee's title, after solemn hearing and judgment at law, should be such as, if presented to his view after a trial at law, would have induced him to set aside the verdict. No interlocutory injunction should issue unless complainant's title be clear, or admitted, for the court is not bound to decide doubtful and difficult questions of law, or disputed questions of fact, nor to exercise this high and, if exerted rashly, dangerous power before the alleged offender has had an opportunity for a full and fair hearing. The chief object is to prevent irreparable mischief, not to give complainant means of coercing a compromise on his own terms. Section 465. If the defendant shows a belief that he is a just defense, and is not a willful pirate, then the case should be one of evident mistake of law or fact, or both, in the defense which he sets up, which will justify the festinum remedium. Section 466. The constitutional right of a trial by jury applies only to actions at common law. In suits in equity, an inquiry by the jury depends upon the discretion of the court, it not being conclusive, but only an aid to the conscience. Section 467. Upon motions for preliminary injunction, if, after a careful and impartial examination of the case, the court be of opinion that the complainant is entitled by law to the writ, it is their duty to grant it without evasion. Section 468. Inequity, if the defendant, without fraud, use the trademark of the complainant, he is still liable. If the right be violated, it matters not whether it be by fraud or by mistake. The whole question in such case is whether the defendant's label or mark is calculated to deceive the public, and to lead them to suppose that they are purchasing an article manufactured by the complainant instead of by the defendant. To entitle a complainant to protection against a false representation, it is not essential that the article should be inferior in quality, or that the individual should fraudulently represent it, so as to impose upon the public, but if, by representation, it be so assimilated as to be taken in the market for an established manufacture, or compound of another, the injured person is entitled to an injunction. The injury is not the less, though the false representations be made without a knowledge of such interference. Section 469. Discovery, account, costs. Although it is not within the scope of this treatise to discuss matters which can be found more fully and more ably treated in books devoted to equity jurisprudence, and in books of practice, still this subject is worthy of observation. In its relation to trademarks, in many cases, the aggrieved party might be at a great disadvantage, unless he had some means of access to his opponent's books and papers, to enable him to fix the amount of injury done by the wrongful conduct of the other. He must look to discovery. How shall he, in the majority of cases, ascertain the amount of sales, unless in this mode? But how shall he proceed? $470. We find a statutory provision by which all courts of the United States have power in the trial of actions at law, on motion and due notice thereof being given, to require the parties to produce books or writings in their possession or power, which contain evidence pertinent to the issue, in cases and under circumstances where they might be compelled to produce the same by the ordinary rules of proceeding in chancery. But this may really afford no remedy. On failure, judgment may be given against the defendant by default, and the plaintiff be left to grope in the dark. He must, then, resort to a court of equity. There the familiar canons of chancery jurisprudence stand in his way. If he seeks discovery to enable him to enforce a forfeiture, for equity does not favor forfeitures. But if he relinquish all claim to a penalty or forfeiture, he may entitle himself to a discovery in aid of an action at law for the recovery of damages. Section 471. Parties innocently bought and sold as genuine an article which was in fact spurious. They were restrained from selling it with the plaintiff's trademark, but were not ordered to account for profits, nor compelled to pay the plaintiff's costs. The Master of the Rolls said, substantially, that the right to an injunction usually carries with it the right to costs. But if a plaintiff asks for costs, and for something more than he is entitled to, he will lose the costs he might otherwise have received. $472. A common carrier, entirely innocent of fraudulent intent, but having certain falsely marked goods in his possession for the purpose of transportation, may be enjoined, but the fact of good faith is ground for refusing costs. This was the ruling in Upman v. Elkin, in 1871. By Lord Chancellor Hatherley, affirming a decree of the Master of the Rolls. A firm of forwarding agents in London received from correspondents abroad a number of boxes of cigars, being counterfeit brands, to be delivered to several persons in England. On application by the makers whose brand had been imitated, the agents gave information against the consignors, and offered to either send back the cigars, or to remove the brand. The Lord Chancellor said, "It has been urged that the plaintiffs were not entitled to an injunction against the defendants, who had been guilty of no offence, being merely carriers receiving goods which, though fraudulently marked, were not for their own use, nor to be sold for them for their own benefit, but were merely received for the purpose of transmitting them to the persons to whom they were consigned. I cannot conceive a doctrine more dangerous or mischievous, or more fatal to the authority of the court with respect to trademarks. If that argument prevailed, persons being abroad, as was the case in this instance, and inclined to commit frauds upon an English trademark, could easily do so by sending their different consignments together to the possession of the defendants, who appear to be reputable agents and warehousemen, thereby committing an injury in a manner most convenient to themselves, and very mischievous to the person entitled to the benefit of the trademark. Section 473. In such a case, the agent may be compelled by a court of equity to disclose the names of places to which goods bearing false marks had been transmitted by him, and all other information that is within his knowledge or may be gathered from his books tending to redress the grievance of the plaintiff, except the names of customers and the prices of the goods.